Swayam Prabha. Digital India. Educated India.
Hello friends, we are discussing the course on the law relating to women and children. This is lecture number 16 on the topic Rights of Women Prisoners. The women prisoners are in very critical situation, in very critical condition in India because of various reasons. There is overcrowding in the jails, there is the lack of or non-availability of the basic needs in the prisons, in the jails, because of the exploitation of the women prisoners by the jail authorities or prison officials, and because of the concerns of women prisoners about their children. One more significant reason for this plight of women prisoners is the delayed justice system in India. And therefore, it is important to discuss the law relating to women prisoners. What are the legal provisions protecting the rights of the prisoners? What are the rights of women prisoners? And where is the lack or where is the problem in implementing or enforcing these provisions to protect the women prisoners' rights? This discussion over the topic, the rights of women prisoners, has been divided into 5 parts. Number 1, the introduction. Number 2, the international mandate. Number 3, the constitutional mandate. Number 4, the legislative initiatives. And number 5, the judicial approach. Under these 5 subheads, I will focus on the rights of women prisoners and the law relating to the protection of women prisoners' rights in India. Women prisoners are in critical position given the fact of non-speedy criminal justice system, overcrowding of jails, unavailability of basic needs in jails, exploitation by officials, and having to worry about the children in their care. If we see the data, in total of 1330 prisons in India, there are only 34 women jails, of which they are situated in only 16 states, and 20 states in the country have no separate women jails. Rajasthan have highest number of women jails, that is 7. Only 34 women jails are there in the country out of total 1330, and in these 34 women jails, only the state of Rajasthan has 7 jails. These 34 jails are situated in 16 states and union territories. 20 states are not still having the separate women jails. This is the data indicated by NCRB Prison Statistics India Report 2022. Of these 34 women jails, the number of inmates are 4258, which have the capacity of 7080 inmates. This means the occupancy rate is 60%. Mizoram have the most overcrowding in women jails, that is 168.8%. This is also the data of NCRB Prison Statistics India Report 2022. Women inmates in jails other than women jails are 19,532 with the capacity of 24,077. This implies the occupancy rate of 81%. 15 1537 women prisoners are with 1764 children, and of these 1537 women prisoners, 1312 are under trial prisoners with 1479 children, and 198 were convicted prisoners with 230 children. There are 202 NGOs, non-governmental organizations, exclusively working for prison reforms for women. In Pudukkottai district jail in the state of Tamil Nadu, there are 3 civil assistant surgeons in women jail to tend to special medical needs of prisoners round the clock. Crèche facility, nursery schools and sanitary pads are also made available for women prisoners in many other states. If we see the international mandate on the rights of women prisoners, first we can refer to United Nations rules for treatment of women prisoners and non-custodial measures for women offenders 2010. Of these United States rules which were laid down in 2010, Rule 25 prescribes that women prisoners of any abuse should be given protection and appropriate steps should be taken to ensure that an independent authority take into account the investigation of the claims of abuse. Principle of confidentiality should be followed. Women who by being victim of abuse got pregnant should receive special medical care. In regard to mental and physical health, women members should be part of the investigators who are accountable for verifying the living condition of women detainees. So, the Rule 25 prescribes that women prisoners of any abuse should be given protection. Women prisoners should be given the protection and appropriate steps should be taken to ensure that an independent authority take into account the investigation of the claims of abuse. Independent authority, there shall not be any bias in the inquiry or investigation as to the claims of abuse. Therefore, there is a need of some appropriate steps to be taken to ensure that the independent authority shall make such inquiry or investigation. It is also provided by Rule 25 of these rules that the principle of confidentiality should be maintained, should be followed, should be adopted, and the woman who is the victim of abuse, if she gets pregnant, she should receive special medical care. So, if any prisoner, woman prisoner has become pregnant, then she should be given the proper medical care in regard to both the mental health and the physical health. It has also been provided by the rule that women members should be part of the investigators who are accountable for verifying the living conditions of women detainees. What are the living conditions of women detainees? If any such inquiry or investigation is made, then the women investigators shall also be in that inquiry. The standard minimum rules for the treatment of prisoners, this is also an international instrument. The standard minimum rules for treatment of prisoners, how the prisoners should be treated, these rules have been laid down for this purpose. The Rule 6 of standard minimum rules for the treatment of prisoners provides, it deals with basic principle that these rules should be applied impartially and without any discrimination on the basis of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. If we see the grounds on which the discrimination among the prisoners is prohibited by Rule 6 of Standard Minimum Rules for the Treatment of Prisoners, one ground is the ground of sex. It means that on the ground of the sex, on the basis of the sex, there shall not be any discrimination with regard to the rights of the prisoners. That also means that the women prisoners shall have the rights equal to the men prisoners. Rule 8 provides that there should be separation in the detention on the basis of sex, age, criminal record, the legal reason for their detention and the necessities of their treatment. Women prisoners, if stayed in the same facility as men, then the area of women should be separate. Though the discrimination is not allowed on the basis of sex, on the basis of color, on the basis of race, on the basis of language, on the basis of religion, on the basis of political or other opinions, national or social origin, property, birth or other status. As we see the incidences in the jails, that the persons belonging to the high economic strata, they are availing each kind of facilities in the jails by the active involvement of the jail authorities or jail officials. The courts have issued the guidelines, the directions to the jail authorities not to stop such kind of treatment, special treatment with those who belong to high economic strata. And this rule 6 of standard minimum rules for the treatment of prisoners prohibits any such kind of discrimination. As we have seen, rule 8 provides that there should be separation in the detention on the basis of sex. Though on the basis of the sex, the discrimination is not allowed, but the women prisoners should be kept separately from the men prisoners. This distinction can be made in accordance with the mandate given by rule 8. This distinction can also be made on the basis of age. We see that this is the ground for having the separate jails for women, for having the separate detention room or detention homes for the offenders below the age of 18 years or child offenders, because rule 8 also provides for that there may be the discrimination on the basis of sex, on the basis of age, on the basis of criminal record also the separation is required, because when a normal ordinary person for any petty offence is detained with those who are habitual criminals or who have the long record of the criminality, then there may be the chances of the influence of those hard criminals over this new person in jails, and he can also become the hard criminal. And therefore, this is the justification for separating the stay of the normal ordinary prisoners from the hard criminals. And therefore, there must be the separation in detention on the basis of sex, age, criminal record, the legal reason for their detention and the necessities for their treatment. Women prisoners if stayed, this is also the mandate of rule 8, that if there are the circumstances in which the women prisoners cannot be kept or cannot be detained in separate jails, they can be kept, they can be stayed, they can be detained in the similar jails where the male prisoners are detained, but with the condition that women prisoners if stayed in the same facility as men, then the area of women should be separate. The area or the place where the women prisoners are detained shall be separate from the area or the place where the men prisoners are detained in the same jail or in the same prison. Rule 23. Rule 23 provides that women prisoners should have prenatal and postnatal care facilities, and the child should be arranged to be born in the hospital out of prison facilities. Number 1, according to rule 23, number 1, women prisoners should have prenatal and postnatal care facilities if they are found pregnant. If any such woman is detained in the jail who is pregnant at the time of detention, or if later on she becomes pregnant, then the prenatal and postnatal care should be provided to that woman prisoner. The child should be arranged to be born in hospital out of prison facilities. It is also the mandate of rule 23 that there must be efforts to arrange the delivery of the child out of the jail, because it is very big social stigma for that child who is born in jail. If a child is born in prison, that details should not be mentioned in the birth certificate. There may be the conditions that jail authorities may not arrange the delivery or the birth of the child out of the jail. In such circumstances, even though the birth was made in, the delivery was made within the jail premises, there shall not be the mention of the jail in the birth certificate. Well qualified nursing staff should be made available to take care of infant when not in care of mother in prison. So, if infants they are not in care of the mother or the woman prisoner, they should be given the proper care by the jail authorities according to Rule 23. Rule 25 talks about a robust inspection in order to check up the facilities of penal institutions and correctional services. Rule 55 talks about that state authorities should make the appropriate measures, appropriate rules, regulations or the law. The appropriate initiatives should be taken by the state authorities about a robust inspection in order to check the facilities of the penal institutions and correctional services. What kind of facilities are being provided, whether these facilities are in accordance with the rights of the prisoners or not. This investigation should be made, this inspection should be made by the state authorities and such mechanism should be developed. This was the international mandate about the rights of the prisoners, women prisoners. Now, see the constitutional mandate. We know that the distinction or the discrimination on the basis of sex, on the basis of any other ground cannot be made in accordance with the mandate given by the Constitution under Article 14, 15. But we also know the fact, in each and every lecture we are discussing, we are referring to Article 15.3. This Article 15.3 makes the state capable of making the separate or the distinctive provisions for the welfare of the women and the children. And therefore, in this regard also, to give the separate treatment to the women prisoners for protecting their own rights, the state authorities have the mandate, constitutional mandate, and according to this, the beneficial provisions for special provisions for protecting the rights of women prisoners can be made. Article 21 is also very basic right. It also gives very basic or fundamental right to every person, right to life and personal liberty. We are also aware of the fact that in jails or in prisons, many atrocities are to be inflicted on the prisoners. Inhuman treatment is being made by the jail authorities, by the police officials, and this inhuman treatment and the jail atrocities are certainly violative of Article 21 of Indian Constitution. Therefore, in the case of Sunil Batra versus Delhi administration, which was decided in 1978, the Supreme Court of India issued the guidelines for the jail authorities to provide for the facilities and not to do the inhuman treatment, or these are the directions to prevent the prisoners in the jail against the jail atrocities or inhuman treatment in the jail. In Sunil Batra versus Delhi administration, it was stated by the Supreme Court of India that fundamental rights do not part company with prisoners at the gate of prison. The fundamental rights do not part company with the prisoner at the gate of the prison. What does it mean? Article 21 is the right to life and personal liberty, and this right to life and personal liberty continues even after the person entered the jail. It does not depart from the company of that person as the person enters the jail. That means that this right to life and personal liberty is not limited only to the extent when the person is outside the jail, and as he enters the jail, he is deprived of this right to life and personal liberty. No, the Supreme Court says that the fundamental rights do not part company with the prisoner at the gate of the prison. Right to life is the right that subsists even in the prison. So, decent, healthy, safe and hygienic facilities should be provided in the jail. Jails or prisons are the correctional rooms. This is the sociological theory of punishment. Under the criminal justice system, there are different theories for the punishment. What kind of punishment should be there? What should be the objective of the punishment? For these, to answer these questions, many theories have been evolved. These theories are the deterrent theory, the sociological theory. Under the sociological theory of punishment, the concept of correctional rooms, the concept of correctional home was developed, was evolved, and the prisons or jails are the result or the consequence of such a sociological thought of the punishment, that correctional homes are constructed, are established, and the offenders or the criminals are kept in those correctional homes. What does it mean? That when the persons or the prisoners, they are kept in or they are detained in jails or prisons, they are kept there for the purpose of correction and not for the purpose of giving inhuman treatment to them. Any person can be corrected only when that person is treated as the human being, and therefore, in the case of Sunil Batra, the Supreme Court says that decent, healthy, hygienic facilities should be provided to the prisoners in the jail. Then we see Article 39A of Indian Constitution. This constitutional provision imposes the duty on a state to require the legal system to ensure justice and equality. Justice and equality can be maintained only when the men and women are treated equally in the jails or in the prisons. The concept of justice and equality can be maintained in the jails only when the just and fair conditions are provided, just and fair living conditions are provided, when there is not the violation of the basic rights of the prisoners in the jail, when the atrocities are not inflicted, when the insult and indignity is not done to the prisoners, when the prisoners are treated well in the jails, only then the justice can be ensured and equality can be ensured. Free legal aid to be provided by legislative or policy action to ensure that the justice is not denied to the people because of social, economic or any other disability. This provision was added by 42nd constitutional amendment in the Constitution. So, Article 39A is also aimed at providing the equality and the justice, to ensure the equality and the justice for the prisoners. It mandates the governments to arrange the administration of the prisons in such a manner that ensure justice and equality to all the prisoners. So, this Article 39A also imposes the duty on the state or the government to make the human treatment, to make the just treatment, to make the equal treatment, and therefore, it is also aimed at the protection of the rights of women prisoners. After taking cognizance of, or after discussing the constitutional mandate, we are to see that what are the legislative initiatives on the part of the state in the follow up of or in the adoption of the mandate given by the Constitution. We have seen that under Article 15(3), under Article 21, under Article 39, the mandate has been given to the state about the prison administration, about the protection of the rights of the prisoners and particularly the women prisoners. Under the legislative initiatives or national legislative actions, the Prison Act 1894 was first passed. Preamble to this act provides that it is an act to amend the law relating to prisons. See, in 1894 the Prison Act was passed, and the preamble of the act provides that it is an act to amend the law relating to the prisons. In 1984 the need was felt by the legislature to amend the law relating to prisons. Section 4 of this enactment provides that states should make appropriate accommodation arrangements taking into account separation of prisoners. See, this is very important provision of this Prison Act 1894. In 1894, this was the opinion of the Indian legislature that appropriate accommodation arrangements should be made in the jails or in the prisons, and at the time of providing the accommodation arrangements in the jails, one important considerations to be taken into account, that is the separation of the prisoners. In international mandate also we have seen that the separation of the prisoners is allowed though the distinction or discrimination is not allowed on the basis of the sex and other grounds, but the separation of the prisoners is allowed on the basis of the age, on the basis of the sex, on the basis of the health conditions, on the basis of the nature of the criminals, on the basis of the criminal background of the criminals, on the basis of other requirements. And therefore, in 1894 Act, it was provided that the appropriate accommodation arrangements taking into consideration, taking into account the separation of prisoners should be made. Section 27 of the Act prescribes that women inmates have right to live separately from the male prisoners. This is the main point which directly relates to the rights of the women prisoners. The women prisoners have the right to live separately from the male prisoners in prisons. This section says that if in a jail both male and female inmates are contained together, then women should be separated in a different buildings or different part of the building, which would ensure prevention from being seen or conversing or being engaged in any form of sexual act with male prisoners, so that they may not be exploited by the male prisoners. So, one right has been recognized, has been protected by this enactment. The women prisoners have the right to separate living in the prisons. Section 33 of the Act provides that if a civil detainee or an convicted inmate is unable to provide for himself clothing and bedding, it would be provided by the superintendent of jail. So, this is also the right of the prisoners. If they are not able to make the arrangement of clothing and bedding, then it is the duty of the jail authorities to provide for the clothing and the bedding to those prisoners. Women prisoners are also entitled to this right to have the clothing and bedding from the jail authorities if they are not capable of arranging the clothing and bedding. Section 35 of the enactment provides that if the medical officer is of the view that the health of the prisoner suffers because of labor or employment he/she is engaged in, he/she would be detached from that work or labor and would be put in other form of work suitable for him or her. This is also seen that the jail authorities engage the prisoners in such works which are not suitable or appropriate to the health conditions of the prisoners, just for the sake of giving them the punishment. It is bad practice. The prisoners should be given the work in the jail in accordance with their health conditions, which they can do easily. And if the medical officer is of the opinion that the particular engagement, particular work which is given to a particular prisoner is not in accordance with the health conditions of the prisoner, or the health condition of the prisoner suffers because of this engagement of the work, then it is the duty of the jail authorities to detach that person from that engagement or from that work and to give him the work or the engagement which is suitable or appropriate to the conditions, health conditions of that prisoner. This rule is also applicable to the women prisoners, and we know that the women prisoners are the special class and certain kind of engagements or works cannot be given to women prisoners to do. So, this 35 will certainly help the women prisoners in this regard. After the provisions of the Prisons Act 1894, we are to see the provisions of Code of Criminal Procedure 1973. Now, this Code of Criminal Procedure 1973 has been replaced by Bharatiya Nagarik Suraksha Sanhita 2023 BNSS. There was section 46 subsection 4 in CRPC. Now, this section 46(4) of CRPC is replaced by, is substituted by section 43 subsection 5 of Bharatiya Nagrik Suraksha Sanhita. And this section 43 of Bharatiya Nagrik Suraksha Sanhita provides that women should not be arrested after sunset and before sunrise. Except in exceptional situation, the woman officer with prior permission from first class magistrate can make such arrest. This is very important provision with regard to the protection of the rights of women prisoners or prospective women prisoners. Section 43 subsection 5 of Bharatiya Nagrik Suraksha Sanhita imposes the restriction or provision on the police authorities to arrest any woman in the night. In exceptional situation, a woman can be arrested in the night, but that arrest can be made only after the prior approval, prior sanction of the magistrate. Now see section 49 of CRPC, which has been replaced by section 46 of Bharatiya Nagrik Suraksha Sanhita, and this section 46 of Nagrik Suraksha Sanhita, which replaces section 49 of CRPC, provides that no use of unnecessary restraint should be made for the person arrested other than which is necessary to prevent his escape. So, no unnecessary restraint or no unnecessary force should be used on the prisoners or for the persons arrested. Only in the circumstance where there is the likelihood that that person may escape, such force can be used, otherwise there is the restriction to use the force in arresting the persons. Section 51 of CRPC, and now this is the section 49 of BNSS. Section 49 of BNSS, Bharatiya Nagrik Suraksha Sanhita, provides that search of an arrested woman need to be done only by another female, keeping into account the strict compliance of decency, right to live with human dignity, right to lead decent life. It is the fundamental right of every woman. And if a woman is arrested, then the search of that woman can be made only by another woman or another female official. Even during the search by the female official should take into consideration all the requirements which are needed to be fulfilled to maintain the decency. So, in the compliance of the decency, strict compliance of the decency, the woman or the female should make the search of any arrested woman. Indian Penal Code, this is the criminal substantive law in India. This has been. Now, this Indian Penal Code 1860 is replaced by Bharatiya Nyaya Sanhita 2023. In 2023, 3 criminal laws were amended and replaced. The IPC or Indian Penal Code 1860 was replaced by the Bharatiya Nyaya Sanhita 2023. The CRPC or the Criminal Procedure Code was replaced by Bharatiya Nagrik Suraksha Sanhita, and the Evidence Act, Indian Evidence Act, was replaced by Bharatiya Sakshi Adhiniyam. Section 376 was there in IPC in relation to the offence or the crime of rape, and now this 376 is replaced by section 64 of BNS. It is important to see that what kind of safeguards were provided in 376 IPC and in 64, now in 64 BNS to the woman. This 64 BNS provides for punishment to be rigorous imprisonment for term not less than 10 years, which may extend to life imprisonment, which to mean for the remainder of natural life, and with fine. For such the strict punishment was awarded, was specified in section 376 IPC and now in section 64 of Bharatiya Nyaya Sanhita. For rape committed by police officer within limits of police station on women in custody, minimum 10 years, and which may extend to the life imprisonment, and in this case the life imprisonment would mean the imprisonment for the remainder of natural life. The whole life the person is to be detained. Such a punishment is provided under section 64 of Bharatiya Nyaya Sanhita, if the rape committed by the police officer within the limits of police station on the woman in custody. If the rape committed by the management or staff of the jail, remand house, women or children's institution on any of the inmates, then the similar punishment is awarded. So, this is very important or significant to see that in IPC under 76 and in the BNS Bharatiya Nyaya Sanhita under section 64, the stringent punishment has been awarded for the persons who are convicted or who are charged with the offence of rape, being the police officer and they committed the offence of rape in the police station, in the premises of police station, on any woman under their custody, and the same punishment is to be inflicted on any person who is convicted of the rape in the jail and he is the jail staff. Now, see the judicial approach regarding this particular issue of the rights of the women prisoners. I referred to the case of Sunil Batra versus Delhi administration at the outset of our discussion. Now, see that why the Sunil Batra versus Delhi administration is the significant decision of the Supreme Court of India with regard to the protection of the rights of the women prisoners and the prisoners in general. The fundamental rights do not get detached from the prisoners at she or he enters the gates of the prison. This is the basic conception which was evolved by the Supreme Court of India, that the prisoners have also the fundamental rights in Sunil Batra case, and they cannot deprived of their fundamental rights even though they are detained for committing the offences. Fundamental rights such as right to life when someone enters the prison is the basic or fundamental right. Certain guidelines were issued by the Supreme Court in the case of Sunil Batra to protect the prisoners from inhuman treatment by the jail authorities. The Supreme Court of India issued the guidelines that there should not be any inhuman treatment in the jails, and if any inhuman treatment is made with any prisoner including the women prisoner, then it would be violative of Article 21 of Indian Constitution, that is right to life and personal liberty. It means that the Supreme Court of India extended the scope of or the meaning of right to life and personal liberty even in the premises of the prisons or the jails, or the prisoners are also entitled for their right to life and personal liberty. The Supreme Court of India within these guidelines provided that the jail atrocities or atrocities inflicted on the prisoners is certainly the violation of Article 21 of Indian Constitution. The basic needs should be provided to the prisoners. Overcrowding in the jails was also taken into consideration by the Supreme Court of India in Sunil Batra case, and the Supreme Court in its guidelines suggested that the government should make the effort to get rid of this overcrowding in the jails. Then comes Menka Gandhi versus Union of India. In Menka Gandhi versus Union of India case, the Supreme Court held that human life should not be confined to mere animal existence. It should be filled with dignity and respect. Right to life includes right to live with human dignity. Then comes Menka Gandhi versus Union of India. This Menka Gandhi versus Union of India is very important case decided by the Supreme Court with regard to the right to life and personal liberty, and particularly with reference to the meaning of procedure established by law under Article 21. The Supreme Court says that procedure which has been enacted even by the competent legislature, if it is devoid of the principles of natural justice, if it is not just, it is not fair, it is not reasonable, cannot be considered to be the procedure established by law for the purpose of Article 21. That means No authority can deprive any person from his or her right to life and personal liberty without the procedure established by law, and that procedure established by law must mean the procedure which is permeated with the principles of natural justice, which is permeated with the fairness, justness and reasonableness. The Supreme Court in Menka Gandhi case held that human life should not be confined only to animal existence. The right to life and personal liberty means the right to live with human dignity. R.D. Upadhyay versus State of Andhra Pradesh, decided in 2006 by the Supreme Court. Friends, this case is a milestone in the area of the rights of women prisoners and the rights of the children of women prisoners. The relevant data was pointed out in this case, and this data led the court to issue certain guidelines to ensure safety and health of women prisoners, especially mothers with kids less than the age of 6 years. So, this is the case which protected the rights of the women prisoners, not only the rights of women prisoners and also the rights of the children of such women prisoners. The Supreme Court says that the children born in prison get a lot of bias in life, which affect their physical as well as their mental health, and therefore, state should focus on their rights, safety, rehabilitation and health. Hussain Ara Khatun versus Home Secretary Bihar, this is also one important case. At very outset, I told you that the rights of women prisoners are in very critical conditions, and the reasons for which the rights of women prisoners are in critical condition, the one important reason is the delayed justice, not speedy criminal justice system in India. Hussain Ara Khatun is the landmark judgment given by the Supreme Court with regard to the rights of the prisoners by stating that right to speedy justice is the part of right to life and personal liberty under Article 21. The free legal aid was also considered to be the part of right to life and personal liberty under Article 21 by the Supreme Court of India. In this case, the Supreme Court says that right to free legal aid as part of fundamental right under Article 21, that is right to life, if they are unable to procure it on their own due to poverty or indigence. So, because of the indigence or because of the poverty, if any prisoner is not capable of arranging the legal aid or the lawyer, then it is the duty of the state to provide the legal aid to ensure the guarantee of right to life and personal liberty. Bail conditions were also discussed by the Supreme Court, and Supreme Court says that these bail conditions create issue of under trials being confined in jails for more than the time period for the conviction of offence if convicted. There are the situation that because of the delayed justice, the persons are kept or detained in the jail for the time more than for their conviction period if they would have been convicted earlier. Such a procedure creates injustice, and therefore, it cannot be considered to be the procedure established by law for the purpose of Article 21 and was held invalid by the Supreme Court of India in this case. Sheela Varse versus State of Maharashtra is also one significant case with regard to the women's and children's right. The Supreme Court held that interviews of prisoners are vital to let the correct information out about the living conditions of the inmates, but such information collection need to be regulated. So, the interview of the prisoners were considered to be vital or significant to let the correct information out. Only by the interview, unbiased or free interviews of the inmates of the jails, the living conditions of the jails can be made public and can be made out, and therefore, the interviews of prisoners were considered to be vital for this purpose. The Supreme Court says, Supreme Court in Sheela Varse case took the suo motu cognizance in 2024. In a case, the Supreme Court took the suo motu cognizance of the case of pregnancy of 198 women inmates while in custody. There was the issue that 198 women prisoners, they became pregnant during their detention in the jails. This shocking news took the criminal justice system by storm and led the Supreme Court to take matter into its own hands. That was the reason the Supreme Court took the suo motu cognizance. This is the seriousness of the Supreme Court of India with regard to the rights of women prisoners. There is one important decision being delivered by the Supreme Court of India in 2019, that is Babul Khan versus State of Karnataka. In Babul Khan versus State of Karnataka, the Karnataka High Court laid down certain guidelines on the basic facilities that government and authorities need to fulfill for women prisoners. This is the most significant judgment of the Supreme Court of India because it deals with the rights of women prisoners. The Supreme Court issued the guidelines on the basic facilities to be provided by the government authorities to fulfill the needs of women prisoners and their children in prison, like health checkups, amenities that would provide holistic growth to children in prison, food, clothing, sleeping facilities, etc. If we look at these guidelines issued by the Supreme Court of India, we can understand that why this decision of the Supreme Court is the most significant decision with regard to the rights of women prisoners, with regard to the protection of rights of women prisoners. According to the guidelines, the Supreme Court was of the opinion, before sending a pregnant woman to jail, the authorities must ensure that availability of basic facilities in jail for the safe delivery and prenatal and postnatal care of women and child. So, before sending any woman to the jail, this is the responsibility of the jail authorities, this is the responsibility of the state authorities to ensure that there are sufficient and adequate facilities for the safe delivery, for the prenatal care, for the postnatal care of women and child. As soon as possible, the arrangement shall be made for medical examination of such women in the female ward of district hospital for ascertaining different issues relating to pregnancy, including the possible date of delivery. Supreme Court guided that after ascertaining these particulars, a report shall be sent to IGP, Inspector General of Police, avoiding the date of admission, term of imprisonment, date of release, duration of pregnancy and prospective date of delivery. It was also directed by the Supreme Court that regular medical examination of the woman shall be performed under proper care, should be given according to the advice of the gynecologist. So, regular medical examinations of the women shall be performed and proper care should be given according to the advice of gynecologist. It was directed that arrangements like release, parole shall be made to enable the woman to have her delivery outside the jail. Only in exceptional circumstances such option may be denied. If the birth happens in prison, then the Supreme Court directs the birth certificate from the concerned local authority shall be issued without mentioning the jail as the place of birth, and only the address of the locality shall be mentioned. As far as possible, the facilities for naming ceremony etc. shall be extended. Female prisoners shall be allowed to keep their children with them till they attain the age of 6 years. These are the guidelines issued by the Supreme Court of India with regard to the pregnancy, the prenatal and postnatal care, the safe delivery, the delivery outside the premises of jail, the naming ceremonies. These rights were recognized by the Supreme Court in these guidelines. In addition to these guidelines, very comprehensive guidelines were issued by the Supreme Court of India for the children above 6 years as to their requirement of food, clothing, medical care, shelter, education and recreation. So, if we see the decision of the Supreme Court of India or the guidelines issued in this decision, it seems that very comprehensive guidelines have been issued by the Supreme Court of India to protect the rights of the women prisoners and their children, and if these guidelines are followed by the jail authorities, by the state authorities in their content and spirit, then certainly the rights of the women prisoners may be protected very properly. Thank you very much.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP, you have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with a 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables, more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So, the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender and by your weight. So, apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So, for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday. So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now after this, we went in for a policy implication, and in the policy implication we tried to find 2 policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has a impact in reducing your probability of getting high cholesterol. and dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators, and it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day, but fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.